the Kuki community has been demanding a separate administration in Manipur, claiming that they arrived as refugees due to political instability in Myanmar. India, as a democratic nation, is often seen as obligated to consider such demands because its constitution offers protections to refugees. However, the Meitei community argues that Kukis entered and remained in Manipur illegally. Historically, some villages were required to pay rent to Naga villages, but today Kukis have stopped these payments and are now demanding that the original landowners vacate the land. This raises the question, what does a separate administration entail, and how does it align with India's constitutional framework? What constitutional provisions protect refugees? India is not a signatory to the 1951 UN Refugee Convention or its 1967 protocol, meaning it lacks a specific legal framework dedicated to refugees. However, the Indian Constitution provides certain protections that can extend to non-citizens, including refugees. Article 21 guarantees the right to life and personal liberty to all persons within Indian territory, not just citizens. This has been interpreted by courts such as the Manipur High Court to include refugees, ensuring they are not arbitrarily deprived of their rights. Additionally, Article 14 ensures equality before the law and equal protection of the laws for all persons, which can apply to refugees in certain contexts. Despite these protections, India's refugee policy remains discretionary, guided by humanitarian considerations rather than a binding legal obligation. What is a separate administration? A separate administration refers to a distinct governance structure for a specific region or community within a state, often with its own administrative and legislative powers. In this case, some Kuki MLAs are pushing for this arrangement in Manipur, possibly to gain political leadership and leverage. Critics, including the Meitei, allege that the motive is to facilitate the influx of more refugees from Myanmar without accountability to the Indian government. This demand stems from ethnic tensions exacerbated by the Kuki-Meitei conflict, where Kukis seek autonomy while Meiteis view it as a threat to their indigenous rights and territorial integrity. How could this happen under India's constitution? The Indian constitution, under Article 3, allows Parliament to form new states or alter existing state boundaries with a simple majority, after consulting the concerned state legislature. Theoretically, a separate administration for Kukis could be established this way, though it would require political consensus and justification beyond ethnic demands. However, creating an administration exempt from central oversight or accountability contradicts India's unitary federal structure, where the union government retains significant control over security, borders, and citizenship matters. The Kuki MLA's alleged intent to bring in more refugees unchecked would clash with national sovereignty and immigration laws, making it constitutionally and practically untenable without amendments or special provisions. Proposed solution and its feasibility. To address this complex issue, you suggest implementing the Citizenship Amendment Act, CAA, and the National Register of Citizens, NRC, in Manipur, with 1949 as the cutoff year, marking Manipur's merger with India on October 15, 1949. Additionally, you propose enforcing the Inner Line Permit (ILP) system alongside border security measures. Here's an analysis. CAA in Manipur. The CAA, enacted in 2019, fast-tracks citizenship for non-Muslim refugees from Pakistan, Bangladesh, and Afghanistan who entered India before December 31, 2014. It does not apply to Myanmar refugees such as the Kukis regardless of religion. Extending CAA-like provisions to Myanmar refugees would require legislative changes, which could face resistance due to its exclusionary nature and the ongoing ethnic sensitivities in Manipur. NRC with a 1949 cutoff. The NRC aims to identify legal citizens and exclude illegal immigrants. Using 1949 as the cutoff aligns with Manipur's integration into India, predating the 1951 baseline demanded by some groups and the 1961 base year adopted by the state for ILP purposes. Applying this uniformly to all communities, Meitei, Naga, Kuki, Muslim, and outsiders, could help resolve disputes over indigeneity and illegal settlement. However, it would require extensive documentation which many residents, especially in conflict zones, may lack, risking exclusion of genuine citizens. ILP enforcement. The ILP, extended to Manipur in December 2019 under the Bengal Eastern Frontier Regulation of 1873, restricts entry and settlement of non-residents. Strengthening its implementation could curb unregulated migration from Myanmar and other states, addressing Meitei concerns about demographic changes. It aligns with constitutional provisions to protect indigenous populations in northeastern states. India's commitment to reinforcing its border security along the 1,643 kilometer India-Myanmar border marks a significant step towards addressing pressing illegal immigration issues. The decision to construct a fence and eliminate the Free Movement Regime, FMR, comes amid growing concerns over national security. As the world grapples with complex migration dynamics, India's approach reflects recognition of the necessity for stringent measures to protect its integrity while navigating humanitarian obligations. Simultaneously, the ethnic conflict in Manipur sheds light on the intricate dynamics between the Meitei and Kuki communities. Historical grievances rooted in accusations of cleansing have fueled animosities, leading to violent clashes since May 2023. Over 250 lives have been lost, and thousands have been displaced, highlighting the urgent need for a compassionate yet balanced resolution. The analogy of tenant and landowner encapsulates the perceptions held by the Meitei, positioning Kukis as outsiders, exacerbating tensions, and hindering potential reconciliation. While some propose establishing a separate administration for the Kuki community as a solution, this may only deepen divisions within Manipur. Such a move could be perceived as catering to specific grievances at the cost of broader unity and stability. An alternative path would involve implementing a uniform National Register of Citizens, NRC, alongside an Inner Line Permit, ILP. This legal framework could determine residency rights, provided it is enforced impartially, promoting inclusivity over exclusion. The complexities extend to India's constitutional provisions regarding refugee status. Articles 21 and 14 provide limited protections, yet they do not endorse separate administrative demands stemming from refugee claims. A balanced strategy is essential, enforcing the ILP and initiating an NRC with a cutoff date of 1949 to address concerns about illegal immigration while maintaining Manipur's integrity. However, the Citizenship Amendment Act, CAA, presently does not encompass Myanmar refugees, signaling a gap in legislative support for those vulnerable populations. Ultimately, effective border security is undeniably crucial. Yet the heart of the solution lies within the channels of dialogue and equitable law implementation. Dialogue must address the fears and aspirations of all communities involved, fostering a path towards understanding and coexistence. Acknowledging ethnic identities should not lead to fragmentation, but rather contribute to a collective vision for peace, security, and harmony.